As a building code administrator, I have had the opportunity to work with some fantastic code enforcement staff. This training on the legal side of the legalism management of your exam and your training is very valuable for you, and I hope it's very helpful for you. So let's get started. We ask that you like and subscribe these videos.
Through enforcement of code, building officials serve as law enforcement officers, requiring compliance with code through procedures defined by legal due process. Such a statement does not imply that they are policemen or have the power of arrest, but indicates that they are involved and responsible for the enforcement of certain laws. To perform their duties and function properly, they are endowed with considerable authority. The mechanics of carrying out or invoking either of the components are governed by applicable laws, including the United States Constitution, which provides the building official with a broad spectrum of legal rights, restrictions, mandates, and prohibitions. Omitting or ignoring any required legal step is not permitted. It dilutes the intent and effectiveness of the law and raises serious questions about the integrity or competence of the building code department, who is responsible and may be held accountable. Section 104.8 of the Building Code. The building official, members of the Board of Appeals, or employee charged with the enforcement of this code, while acting for the jurisdiction in good faith and without malice in the discharge of their duties, shall not therefore be rendered liable personally for any act of omission in the discharge of official duties. This does not preclude a lawsuit from being filed and adjudicated. The building official and their agents and the local government may be considered as two separate entities. When a lawsuit is brought, the concept of joint and several liability allows the plaintiff to recover damages from two or more defendants. Code officials who intentionally or recklessly fail to perform a required duty and thereby cause injury may be prosecuted in those states which have criminal law provisions for such actions. Intentional, malicious, and grossly negligent conduct against the code are not defensible under sovereign immunity. 4 standard theories of liability. Number 1, negligence. Failed a duty, no intent was needed. Intentional tort, knowingly violated a duty. Civil rights violation, violated a protected right. Criminal violation, intentional or a reckless act. The 2 primary governmental defense actions include the public duty doctrine and sovereign immunity. According to the court, the public duty doctrine is a focusing tool used to determine whether the state owed a specific duty to a particular individual, the breach of which is actionable, or merely a duty to the nebulous public, the breach of which is not actionable. In its broadest terms, sovereign immunity stipulates that the state may not be held liable for any wrongdoing which it or its agents have committed. This ancient doctrine originated in England, where it was widely accepted that the king could do no wrong. Immunity can further be defined as absolute or qualified. Absolute is a policy of protecting public officials from tort liability. A high-level officer cannot be held liable for the discretionary acts or omissions, and it only applies to actions that are functions of the job. Qualified immunity is more likely to be used for building officials and inspectors. The qualified immunity given to lower administration officers is much more commonly applied by the courts. The rationale behind a qualified privilege is that it is sufficient to protect the honest officer, and the burden and inconvenience of any injury regarding motives far outweighs the possible evils of deliberate misconduct. For example, in Rotkamp v. Young, a zoning official was sued for his failure to issue a building permit for a restaurant. The official found that the description of the activity given to him on the application did not meet the applicable provisions of the zoning ordinance. On this point, the zoning official was overruled via a declaratory judgment, but the court found no tort liability. Respondent superior holds the principal responsible for the wrongful acts of the agent. Therefore, in theory, your supervisor and employer can be held responsible for your failures. However, most states extend sovereign immunity to the government employer and supervisors for negligence performed by acts of the employee caused by either accident or mistake. Liability of the employee, supervisor, and agency depend on jurisdictional laws. A ministerial act is a duty that does not involve the exercise of judgment. A building inspector working under the authority of a building official is an example of a ministerial position. That is, the inspector's work is delegated and performed under the authority, policies, and procedures of the building official. A ministerial act is performed because the law requires it. The act does not involve discretion. The work of the building inspector, as well as the permit tech and other office staff, is considered ministerial acts. When a law, policy, or directive clearly establishes that an act must be performed, the relevant officials are not free to exercise their own judgment in determining whether to perform the act or not. Terms often used are shall, must, and will. A discretionary act is an act of choice. It is a power or right bestowed upon an officer acting officially under certain circumstances, according to the dictates of his or her own judgment and conscience, uncontrolled by judgment or conscience of others. The International Building Code uses words that authorize the building official to carry out discretionary acts. IBC Section 104.10, for example, states that the building official shall have authority to grant modifications in individual cases under certain circumstances. This is an example of a building official being authorized to use his or her own judgment. The most common debate concerning ministerial and discretionary acts centers on inspections. Some are discretionary, while others are ministerial. Two large sources of litigation: failure to inspect where required by law, and performing an inspection in violation of the law. A breach of duty is an element in a negligence cause of action. It is the neglect or failure to fulfill in a just and proper manner the duties of an office. The duty owed by the building official must in some manner have been violated. If the duty is satisfied, no liability will ensue. There are essentially two ways in which a duty can be breached: by action or by inaction. For example, failing to make a required inspection would be considered inaction, which breaches a care of duty. Most building code problems result from inaction. An inaccurate inspection would be considered an active breach of duty. To use more legal terms, a breach of duty can result through misfeasance, nonfeasance, or malfeasance. Misfeasance is the improper performance of some act by a person. Malfeasance is the doing of an act that a person ought not do at all. Nonfeasance is the non-performance of some act by a person who is obligated or has the responsibility to perform. In a negligence case, duty may be defined as an obligation to a particular standard of conduct toward another. Breach of duty can be defined as the neglect or failure to fulfill in a just and proper manner the duties of an office. To prevail on a claim of negligence, a plaintiff must satisfy four elements. The defendant, possibly a building official, must have 1. Owed a duty to another to act according to a certain standard. 2. Failed to act in accord with that standard, and therefore 3. Breached that duty. 4. Thereby causing, in the eyes of the law, an injury or damage to the other. The plaintiff must prove each and every element of a negligence claim by a preponderance of the evidence. For example, if a building inspector has a legal duty to inspect every building in the manner that an ordinary, reasonable, and prudent building inspector would, and he or she has not done so, the first two elements of the legal theory have been satisfied. That inspector had a duty and breached it. On the facts alone, a non-attorney would likely believe that this building inspector was indeed negligent. If the inspector's failure to inspect properly, however, did not cause the party to whom the duty was owed a legally recognized injury, there will be no legal liability. In most cases involving building codes, the question becomes, to whom is the duty to act owed? If the plaintiff is not owed any duty of care by the defendant, the first element of the cause of action is missing, and the case is subject to dismissal. To protect the building official, most states have adopted the public duty doctrine. This doctrine provides that a plaintiff who is alleging inadequate performance of a governmental activity has the burden to show that the municipality owed a duty to the plaintiff and not just to the general public when performing the activity that gave rise to the complaint. If the activity is designed for the general public, the cause of action fails for lack of legal duty to the plaintiff. Under the public duty doctrine, the courts would look to the purpose of the building code to determine to whom the building inspector owes a specific duty. Therefore, because the purpose of the building code is to ensure the safety and protection of the public at large, a plaintiff's cause of action against the building inspector will probably fail. If a building official approves a building permit for a building with faulty wiring, and the building burns down, all those people whose family members were killed in the fire do not have a claim against the inspector. The courts will find that the duty was owed not only to the inhabitants of the building, but rather to every member of the public. Because the duty was not limited to the people who lived in the building, the duty element of negligence cannot be satisfied. There are, however, two exceptions to this doctrine. The first occurs when a plaintiff can clearly establish that the building official owes a specific duty to a class of people, and the plaintiff is a member of that class. The second exception occurs when the plaintiff can show that there exists a special relationship between the building official and the plaintiff, which would cause the plaintiff to rely on the building official more than he would the general public. These exceptions are almost impossible to satisfy. There are some states that do not adhere to the public duty doctrine. It is very important to consult with the municipal attorney to determine whether or not the state you are living in has the public duty exemption. Because case law is ever changing, this should be checked every few years to make sure that the law has not changed. Let's look at two cases involving the public duty doctrine. In Emringley versus Town of Richmond, the facts of the case were these. The plaintiffs sued the Town of Richmond and the code enforcement officer for failure to properly inspect construction of their house. Problems began to occur with the construction after the issuance of the building permit to modernize their home. It's interesting to note that a certificate of occupancy was prepared but never delivered to the plaintiffs. The courts held that a municipality is not liable for the negligent acts of its employees engaged in a discretionary municipal function. Without evidence of a special relationship between the town and the landowner, no recovery was allowed. In our second case, Pike versus Morgan, the facts of the case were these. Plaintiffs sued the city for negligence for breaching its duty to properly inspect and approve the construction of the foundation of their residence. The city issued a building permit to the contractor owner to build an addition onto the home. The home was inspected over 40 times for compliance with the building code, and a certificate of occupancy was issued. The property was subsequently sold to the plaintiffs. In the hearing, the experts testified that there were numerous violations of the building code. The city argued that the public duty doctrine shielded it from liability because it did not have a special duty to the plaintiffs, just to the public at large. In the court finding, they held that they would decline the public duty doctrine argument. The court found that the city was liable for damages caused by an employee's negligence, and under the circumstances, the employee would be personally liable to a claimant in accordance with the laws of that state. It did find that the legislature could choose to limit the liability for local government in this area by passing necessary statutes. The word tortious is used to denote the fact that conduct, whether by act or omission of act, is of such a character as to subject the actor to liability under the principles of the law of torts. To establish tortious act, plaintiff must prove not only existence of actionable wrong, but also that damages resulted therefrom. Intentional torts, as the name implies, involves conduct that the actor intended to occur. Negligence, on the other hand, involves conduct that was not intended to cause harm, but nonetheless did so, and also breached some duty of care imposed by law. Legal due process is another constitutional right a building official must be careful not to violate. It involves both procedural and substantive due process. The term procedural due process means that parties whose rights are to be affected are entitled to be heard and therefore must be notified. As an example, if a builder has his or her occupancy permit revoked, the builder must be heard prior to the time of the revocation. In some cases, however, the court will waive the procedural due process requirements. For example, if immediate revocation is absolutely crucial to the health and safety of the inhabitants of the building, the court might waive the owner's procedural due process requirement. A building official, however, should never assume that the court will do this. Rather, the building department should, if possible, always give the owner an opportunity to be heard. The term substantive due process means that any and all legislation enacted by government must bear some rational relationship to a legitimate governmental function. In other words, the law must make sense. Courts adjudicate constitutional issues when the parties raise claims of constitutional rights, usually under the 5th and 14th Amendments, as a defense to the actual or threatened enforcement of law against them. If they determine that a law deprives people of their rights under the Constitution, legislators will be on the alert that in the future courts will find this type of law to be unconstitutional. Case study, procedural due process, Massey versus Charlotte County. Facts. The Charlotte County Code Enforcement Board imposed a lien on property owned by the plaintiffs for failing to obtain permits before constructing improvements on their land. The plaintiffs received notice of and participated in the hearing that found them in violation. Subsequently, a building inspection supervisor submitted an affidavit of noncompliance for their failure to comply with the permit requirements after the first hearing. He asked for a fine of $100 per day. The board issued such an order without notice to the plaintiffs. Held. The court found that the plaintiffs were not afforded procedural due process because there was no process established whereby the plaintiffs could contest the imposition of the daily fine. They had received due process during the first hearing, but not at the subsequent order by the board. Until the early 1960s, federal, state, and local governments were almost completely unaffected by civil rights legislation. In 1961 and in the years following, the Supreme Court has begun to interpret hereunto untapped legislation that proved cause of action for people who suffered civil rights violations at the hands of the government. As of yet, lawsuits brought under the Civil Rights Act have not posed too much difficulty for building officials. As is true with state lawsuits and state legal theories, building officials are difficult to reach. Liability against building officials is difficult to establish in a federal lawsuit. Section 1983 is a cause of action under which a state or local government can be held liable for money damages and declaratory relief for violating the Constitution or laws of the United States while acting under the color of state law. Some commentators have declared that no statute is more important in contemporary America than Section 1983. Nevertheless, before 1961, the Civil Rights Act of 1871 was rarely invoked. In the last 35-plus years, however, this statute has become the basis for almost all constitutional rulings arising from the actions of state and local governments and their officers. To review a few definitions in our program, Ministerial Act is working under the authority of a supervisor. A writ of mandamus is a court order where the court commands the municipality to perform one of the duties it is responsible for performing. A summary action is an action such as a stop work order. Actionable means that for which an action will lie, furnishing legal grounds for an action. To continue with definitions, estoppel Estoppel is a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously said or agreed to by law. It is meant to prevent people from being unjustly wronged by the inconsistencies of another person's words or actions. Estoppel can be understood by considering examples such as the following. A city entered into a contract with another party. The contract stated that it had been reviewed by the city's council and that the contract was proper. Estoppel applied to stop the city from claiming the contract was invalid.
Remember to subscribe, like, and support these efforts that we're having for you, and we wish you the very best of luck in your professional development.